Good morning to you. We'll continue with the Constitution class. Today we are taking up right against exploitation, consisting of Article 23 and 24. So far we have seen right to equality, 14, 15, 16, 17 and 18, right to freedom, 19, 20, 21 and 22. Now, right against exploitation, Article 23 and 24. As we know, the Article 23 prohibits traffic in human beings, that is a beggar. Beggar seems to be Urdu word. Forced labor and other similar forms of forced labor. Any contravention of this practice, any contravention of this article will be punishable under law. This right is both against the state as well as the individuals. It is available to both citizens and non-citizens. Traffic in human beings is a wide term which includes selling and buying of men and women and children as a commodity, like goods. Immoral traffic in women and children, Devadasi system, and slavery have also been included under this. Parliament made Suppression of Immoral Traffic Act, as you know, which was renamed as Immoral Traffic Prevention Act 1956. It also includes the time-old system of exploiting the tenants to rental service without payment by the zamindars in the earlier days. And it included the bonded labor, that is dead bondage, that is without payment, a person is enslaved and the work is extracted. It also includes working for less than minimum wage. Government of India has made a number of acts, laws. Bonded Labor System Abolition Act 1976, Minimum Wage Act 1948, Contract Labor Act 1970, Equal Remuneration Act 1976. This article does not, however, prohibit forced labor as a punishment for criminal offences prescribed under Indian Penal Code. It also permits the state to allow compulsory service for public purposes, military or social purpose. However, in doing so, the state shall not discriminate on the ground of religion, race, caste, or class. Remember, sex has not been included here because discrimination can be done on the basis of sex for obvious reasons. While dealing with the sex workers, remember, it has been held that exchange of sexual service for money is not a crime. However, soliciting paid sex in public place or running a brothel or pimping, etc., have been made offences. Forcible repatriation of or sending sex workers to rescue home are against Article 19 and 21. Ideally, the conventional approach of viewing prostitution as exploitation should be replaced by exploitation of prostitution. That is the view of in one of the cases decided by the court. Next, we are coming to Article 24. It deals with child labor. No child below the age of 14, remember, below the age of 14 should be employed in any factory or mines or in any hazardous activity. However, it does not prohibit employment of children in any harmless or innocuous or innocent work. Child Labor Prohibition and Regulation Act 1986, Employment of Children Act 1938, Factories Act 1948, remember 1948, Apprentice Act 1961, Plantation Labor Act 1951, etc., prohibit employment of children. The Commission of Protection of Child Rights Act 2005 was enacted to provide establishment of NCPCR, that is National Commission, both the National Commission and State Commissions for protection of child rights, and children's courts have also been provided under this act for speedy trial. It is important to note that this act does not prohibit employment of children above 14 years. So remember, in my view, this article may undergo change in due course of time so that the higher education is also given to the students, to the children. So this article may undergo certain changes in due course of time. So we have seen 23 and 24. That is right against exploitation. Now we are coming to right to freedom of religion. Remember, freedom of religion contained in the article 25, 26, 27 and 28. These four articles are contained in right to freedom. This right to freedom is also called secular rights. This is again also called religious rights. The term secular has not been found in the original constitution. Remember, it has not been found in the original constitution. But the spirit of secularism is already there in Article 25, 26 and 28. 26, 25, 26, 27 and 28. These four rights, the spirit of secularism has already been found, included in the original constitution itself, though explicitly it has not been added in the constitution. Nevertheless, the term secular has been added, remember, from the examination point of view, in the preamble through 42nd Amendment Act 1976. 42nd Amendment Act 1976, which is called mini constitution. Remember. Next point you should remember is the secularism has not been defined in the constitution. However, the term has been defined in various judicial interpretations. What is secular? Secular means the state has no religion of its own. First point. Secondly, the state is neither pro-religious nor anti-religious nor irreligious. Remember, the state is neither pro-religious nor anti-religious nor irreligious. The state, as far as in the eyes of the state, remember, all religions are equal. It prefers no religion but promotes every religion. As far as religion is concerned, the state is neutral. The doctrine of non-interference in religious affairs can be seen even in judicial decisions, except with reference to the office or except with reference to property. Judiciary, to my knowledge, has never interfered in any sphere of religion. The judiciary is not supposed to pronounce the truthfulness of any religious trait, nor in manner of worship, nor how a dead body is to be buried. In a nutshell, the state as a political institution is concerned more with the relations between man and the state, rather than the relations between man and the God, leaving the latter, that is man and the God relations, leaving this to the personal individual opinion. Never interfere. State never interferes. Remember, that does not mean we have no faith in God. Sarvapalli Radhakrishnan says the reality of unseen is inbuilt in our constitution. The reality of unseen, quote, unseen, is inbuilt in the constitution. So we are neither pro-religious, nor anti-religious, nor irreligious. Remember, nor irreligious. Most importantly, in S.R. Bommai versus Union of India, 1993 case, Supreme Court declared that secularism is a basic structure. If any particular political party preaches against secularism, it is competent for the Election Commission to derecognize it. Similarly, if any state government works against secularism, Article 356 can be invoked. So, this is the definition of preamble of the secularism. Now we come to the articles. There are 4 secular rights. Article 25. Number 1. First is Article 25. That is, it spells the freedom of conscience and free profession, practice and propagation of religion. Remember, very easy to remember. It speaks about the freedom of conscience and free profession, practice and propagation of religion. This is Article 25. Article 26 deals with freedom to manage religious affairs. This is number next. That is 26. 27 deals about the freedom of payment from taxes for promotion of any particular religion. Number 3. Number 4, that is the last is, that is Article 28 is freedom from attending any religious institutions and worship in any educational institutions. So, these are all the 4 rights. Of this first right, Article 25 speaks about freedom of conscience and freedom to profess, practice, propagate any religion. Remember, the Article 25 actually states, what does it state? Subject to public order, morality and health. Easy to remember. POM. P-O-M-H. POM. Subject to POM and also other provisions of Part 3. What is Part 3? Fundamental rights. All persons are entitled to freedom of conscience and to freely profess, practice and propagate religion. So, this is the guarantee given to all religious communities of freedom of conscience and freely profess, practice and propagate religion of his choice. This is first right. However, the state can make special provision by law on 2 spheres, on 2 counts. Number 1, remember, number 1, to regulate or restrict. To regulate or restrict any economic, political, financial and other secular activities. 4 activities, remember. What are those? Economic, financial, political and other secular activities associated with the religious practice. This is number 1. Similarly, the state can make law for social welfare and social reform. 2 things, social welfare and social reform, or throwing open Hindu religious institutions to all sections of Hindus. So, social welfare, social reform, throwing open all religious institutions to all sections of Hindus. No discrimination. So remember, this is the Article 25. Remember, when you talk of Hindus, very important from the point of examination, when you talk of Hindus, Hindus include Sikh community, Jains and Buddhists. It has also been held, remember, wearing and carrying kirpan among the Sikhs is a part of their religious practice. So, wearing kirpan and carrying kirpan is part of religious practice of Sikh community. Secondly, in one of the cases, Supreme Court also held that the Brahmins do not have the monopoly over performing puja in a temple. Accordingly, a non-Brahmin can be appointed as pujari, provided, remember, most importantly, provided he is properly trained, number one, well versed with the rituals, number two, and well versed with the mantras to be recited. Three, that is well versed in all the three areas. And similarly, another point you should remember, right to propagate religion does not give any right to forcibly convert. No forcible, no allurement, no conversion under force, under fraud. This is very important. It is not a right, because forcible conversion disturbs the public order. What is that? Why? Starting in the start itself, it has said, subject to public order, morality and health. So, forcible conversion of one person to another religion, it disturbs the social peace, public order. Secondly, in another case, Supreme Court held that Aurobindo Society and Aravalli were not religious institutions. So these are all the points of Article 25. Article 26, 27, 28, we will see tomorrow. Thank you very much. I have already requested you, when you take down, you should scribble down the important points, because the proof of pudding is in the eating. Unless you know the points which are important from the examination point of view and which are relevant, you should note down. And if there is any doubt, I may be wrong also, don't go, whatever I say need not be correct. You can cross check. If I am wrong, I will be grateful if you point out this. Thank you.